Hello friends, in the last episode we discussed up to section 26 of the Indian Evidence Act. Today I will start from section 27. Section 27 is closely related to section 26. Section 27 starts with, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. What is that? The principles of this section is, the section is founded on the principle that if confession of the accused is supported by any discovery of fact while the accused person is in custody, he made a statement that he kept the dead body in a bush, and based on his statement, police went there along with the accused person and recovered the dead body. So this recovery is closely related to the statement of the accused. This section is founded on the principle that if the confession of the accused is supported by discovery of fact, this discovery of the dead body, it may be presumed to be true and not to have been extracted. It comes into operation only, please note, it comes into operation only if and when certain facts are deposed as to discovered in consequence of information received from an accused in police custody. So while the accused is in custody, police received some information from the accused, and based on that information, some material facts have been recovered, recovery of the dead body. So this will be relevant. And number two, if the information relates distinctly to the fact discovered. The broad ground for not admitting confession made under inducement, threat or promise to a police officer is the danger of admitting false confessions. But the necessity for the exclusion disappears in a case provided for by this section when the truth of the confession is guaranteed by the discovery of facts in consequences of the information given. So, while confession made by an accused person while he is in police custody is not taken into consideration, because there is a danger that by use of any force or threat or inducement or anything, police can obtain a false confession also. By use of force, police can make a false confession by any person while that person is in police custody. To avoid that evil, confession made a person while in police custody is not taken into consideration. But this section is an exception to that principle, because provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. But when the statement made by an accused person while he is in police custody and following that statement any material fact is discovered, then that statement can be proved. Now, A very short discussion of section 25, 26 and 27 is very much important for those who are taking preparation for judicial service. The scope and effect of the provisions of these sections are no confession made to a police officer by an accused person, whether in custody or not, can be proved against the accused person unless it is made in the immediate presence of a magistrate. We have to study section 25, 26 and 27 conjointly, and a conjoint study of these three sections reveal the basic ingredients for this confession. So much of the information received from a person accused of an offence in custody of a police officer as relates distinctly to the fact thereby discovered is admissible under section 27 and can be proved against him, but any statement made to a police officer which connects the fact discovered with the offence charged with is inadmissible. Very interesting thing. I am reading again. So much of the information received from a person accused of an offence in custody of a police officer as relates distinctly to the fact thereby discovered is admissible under section 27. Fact discovered following the statement made by the accused. But any statement made to a police officer which connects the facts discovered with the offence charged is inadmissible. Sounds almost same, but there is a difference. Discovery should be made following the statement of the accused person while he is in custody. Then that statement can be proved. But there is a discovery of fact and there is a statement. This discovery of fact is not connected with the statement made. This discovery of fact is not in pursuance of the statement made by the accused. So this discovery of fact cannot be said that this discovery was made following the statement of the accused in custody. So this statement cannot be proved. So what is the difference? When the discovery is following the statement of the accused, then it can be proved. But if the discovery is made otherwise and the statement is made otherwise, though both are connected, that cannot be proved. Kerala High Court in Abdul Samad versus the State, AIR 1959, KER page 46. Kerala High Court held that where a fact is discovered as a consequence of information furnished by several accused, only the information which is first given by one of the accused is admissible if it leads to the discovery. This is a very important judgment passed by the Honorable High Court at Kerala, that if there is more than one accused, where a fact is discovered as a consequence of information furnished by several accused persons gave some information and following that some fact has been discovered, then what will be proved? Admissible? Only the information which is first given by one of the accused. The information first received is admissible. Same information or similar kind of information has been given by several accused persons in a particular case, but the information first received, that will be admissible and the others are not. Now I am I am going to section 28. If such a confession as is referred to section 24 is made after impression caused by any such inducement, threat or promise has, in the opinion of the court, been fully removed, it is relevant. This is another exception. Initially, there was some inducement, threat or promise upon the accused person to make some admission. But later, that inducement, threat or false promise, such impression has been removed, and the accused person made such confession after the removal of all those influences. If the court thinks that the confession, though there was some inducement, false promise, threat, etc., otherwise influence upon the accused person to make such confession, but the confession made after removal of all such influences, then it is relevant. This is another exception to that rule. Section 29. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. This is another exception. What is the meaning of this section? A relevant confession does not become irrelevant because it was made. If the confession is relevant, it will not become irrelevant because it was made under a promise of secrecy. You tell me what you have done with Mr. X. I will not tell anyone. Promise of secrecy. This is promise of secrecy. In consequence of a deception practiced on the accused. Say there are two accused, accused A and accused B. Both are under custody. They are in separate cells. And police officer went to first accused A, and told him that accused B admitted his guilt, that you and accused B committed the murder. Now it is up to you whether you will confess it or not. But keep it in mind that accused B did not tell anything. This is a practice of deception. Police officer gave some false to accused A to get that confession. When the accused was drunk, very simple, in answer to questions which the accused need not have answered. Accused answered some questions which there was no need for him to answer. If he answered those questions, those will go against him. This exception is closely related to section 313 of Code of Criminal Procedure. After this video session, please read section 313 of the Code of Criminal Procedure. You will understand this fourth ingredient of section 29 of Indian Evidence Act. And fifth ingredient is, in consequence of the accused not receiving a warning that he was not bound to make it and that it might be used against him. This is also related to section 313 of the Code of Criminal Procedure. So, ingredients number 4 and 5 are related to section 313 of the Code of Criminal Procedure, where court asks some questions to the accused persons, and accused is not bound to answer those questions. But if he answers any question, that may go against him. Now I am coming to section 30. When more persons than one are being tried jointly, A, B, C, are charged with a murder. When more persons than one are being tried jointly for the same offense, and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. Accused A, B, and C. These three are being tried, are charged with murder of Mr. Ram. A made the confession that yes, I along with B and C murdered Ram on such and such date at such and such place and such time. And if it is proved, that will also be proved against B and C. Offense as used in this section includes abatement of or attempt to commit the offense. Offense in this section includes abatement to commit a crime. A murdered Mr. X. B gave him the knife. C told that blow the knife in this way. All these are abatement, and they are being tried together. I am coming to the illustrations of this section. A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C. A stated, and this statement has been proved. The court may consider the effect of this confession as against B also. Illustration B. A is on his trial for the murder of C. There is evidence to show that C was murdered by A and B, and that B said A and I murdered C. The statement may not be taken into consideration by the court against A, as B is not being jointly tried. Note it. In the first illustration, A and B are being tried jointly, but in the second illustration, A and B are not tried jointly. There may be separate trial or something else, but only trial is going on against A, and this statement is made by B, so that cannot be considered. So the ingredients of this section 30 is more than one accused persons if they are tried jointly. Any confession made by one of the accused persons can be taken into consideration, can be proved against other accused persons also. But the key point of this section is they should be tried jointly. And the last section of today's discussion is section 31. Admissions are not conclusive proof of the matter admitted, but they may operate as estoppels under the provisions hereinafter contained. Previously we discussed may presume, shall presume, and conclusive proof. Now, section 31 states that admissions are not conclusive proof of the matter admitted, but may operate as an estoppel. There are two plots. One belongs to me and one belongs to Ram. As far as my knowledge is concerned, that plot A belongs to me and plot B belongs to Ram. And I stated it, that the plot number B belongs to Ram and I am not the owner of this plot, and owner of this plot is Mr. Ram. This is my admission. This admission doesn't mean that Ram and only Ram is the owner. If after thoroughly searching and thorough verification it is found that not Ram but Shyam is the owner, then Shyam will be the owner, not Ram. But it will operate as an estoppel that I am not the owner. I cannot claim ownership of that land in future. Following my admission, it is not guaranteed that Ram will become the owner of that particular plot. Any other person may become owner of that particular plot after thorough verification of all the papers and documents and instruments. But it will operate as an estoppel upon me that I am not the owner of that particular plot. So I tried my best to explain up to section 31 of the Indian Evidence Act. I will be very happy if my discussions help you in any matter, in any ways. I will be very happy to get emails from you. If you have any doubts, any query, feel free to email me. I will be very happy to reply to your emails. From my next session, I will start from section 32. Before concluding this episode, I want to request you all to kindly share and subscribe this channel. And till the next episode, I am taking your leave. Stay blessed.